Hey, it's Mark here, and welcome to the next edition of the Employee Survival Guide, where I tell you, as always, what your employer does definitely not want you to know about, and a lot more.
Imagine giving over 30 years of your life in just, totally loyal service to a single company.
Right, which, that's incredibly rare these days to begin with.
Oh, it's basically unheard of now.
Well,
but you're there for them through these massive corporate changes. You endure the stress of acquisitions, the chaos of completely relocating physical facilities, the constant churn of new management.
Yeah.
You dedicate your entire professional career to keeping their physical operations running smoothly. You are the ultimate company man.
Exactly.
Then, out of nowhere, you suffer a massive, life-threatening medical emergency. Like, you are hospitalized. You literally fight your way back, you get cleared by your doctor, and you return to your desk ready to pick right back up where you left off.
And you think, they're going to welcome you with open arms.
Right. But instead, exactly 2 weeks later, you were called into a room and fired.
Wow.
But wait, they don't just fire you. They ask if you wouldn't mind sticking around for another month to train your 30-something replacement.
It sounds like a dystopian corporate nightmare, right? The kind of story that gets passed around on internet forums as a cautionary tale.
Yeah, like something out of a movie.
But this is exactly what happened in the legal case we are examining today. And what makes it so compelling isn't just the sheer audacity of that timeline. It's how this specific scenario perfectly illustrates the brutal collision between a company's bottom line and an individual's livelihood in the modern economy.
Welcome to the Employee Survival Guide, produced by employment attorney Mark Carey. Today, we are going to dissect the fascinating legal battle of Gary T. Ramaday versus Radial USA Inc.
We have a ton of material to get through today.
We really do. We have a mountain of court documents, summary judgment rulings, and trial verdicts. Our mission is to examine the intricate facts of this case and the ultimate multi-$100,000 holding. We're going to look at exactly how corporate cost-cutting collided with employee rights during the height of the COVID-19 pandemic.
Right, and why the fallout from this one single termination provides such a critical roadmap for everyone listening. Absolutely. And we really need to understand the mechanics of what happened here, because this case is, it's a masterclass in how federal and state employment laws operate on the ground.
Yeah.
It exposes how courts sift through evidence long before a jury ever sees the inside of a courtroom. And crucially, it demonstrates how a single, seemingly minor contradiction from a corporate executive during a deposition can just completely unravel a multi-million-dollar defense strategy.
Exactly. So whether you are a manager who has to make tough staffing calls and navigate the corporate hierarchy, or you are an employee trying to manage your own medical leave while quietly worrying about your job security, the microscopic details of the Ramaday case provide a blueprint for survival.
They really do.
So let's establish the history here.
Yeah.
Gary Ramaday was originally hired by a company called Applied Engineering Products more than 30 years ago. He was their facilities manager.
Right, so we're talking about the early 90s.
Yeah, a long time ago. Then in 2005, a global company called Radial, which is headquartered in Arizona but has these massive international offices in France, Mexico, and across the U.S., they acquire Applied Engineering Products.
Right, and during that 2005 acquisition, Ramaday just keeps doing his job. He transitions over and becomes the facilities manager for Radial's 65,000 square foot manufacturing plant in New Haven, Connecticut.
Which is a huge space to manage.
It is, and for a long time, his trajectory is purely upward. By 2007, when that New Haven facility is at its peak operational capacity, Ramaday isn't just a solo operator. He is managing a dedicated team of 5 maintenance workers.
Okay, so he's a real manager with a real team.
Exactly. He is well regarded by upper management. He receives significant, consistent raises over the decades in recognition of his value. And, the legal record shows he had an completely unblemished performance history.
Wow.
No disciplinary issues, no write-ups. He is the definition of a legacy asset.
But, legacy assets are often the first casualty when the corporate tectonic plates start to shift. And that's exactly what begins to happen here.
Yeah, unfortunately.
The documents show that over the next decade, Radial's business model fundamentally evolves. They start moving away from manual, electrical, and mechanical manufacturing, and they pivot hard toward high-tech, digital-type production.
And it's fascinating how changes in those abstract production methods immediately dictate physical facility needs, right?
Oh, totally.
Yeah.
Because around 2017 or 2018, Radial relocates its entire antenna chamber to France, and they completely eliminate the New Haven machine shop.
which sets off a chain reaction. Because when the physical footprint of what needs to be maintained starts shrinking, the personnel needed to maintain it shrinks too.
Right.
So Ramaday's 5-person maintenance team slowly dwindles through attrition and restructuring. By October 2018, it was literally just him left.
Oh, man.
Yeah, he went from managing a team to being a one-man band, solely responsible for holding down the facility's management for this massive building.
It's kind of like being the captain of a massive cruise ship that slowly gets downgraded to a tugboat over a 15-year period, right?
That's a great way to put it.
But you're still expected to steer it with the exact same title, the same salary, and the same level of institutional knowledge. Like, you know the writing is on the wall.
You do.
And then the physical footprint actually literally shrinks. In December 2019, Radial officially moves out of that massive 65,000 square foot New Haven plant and relocates into a much smaller 30,000 square foot facility in Wallingford, Connecticut.
Right, they cut their physical space by more than half.
Exactly. And we all know exactly what happens to the global economy a few months after December 2019.
Yeah, we sure do. The calendar flips to 2020, the COVID-19 pandemic hits, and supply chains just completely freeze.
And this is where Radial builds the entire foundation of their legal defense, isn't it?
It is. According to testimony from Radial's president, Matite Tristan Magarino, the pandemic had a brutal, immediate impact on their finances. I mean, they reported a staggering 34.8% negative growth in 2020 compared to 2019. Wow.
And they were projecting another 11% loss for 2021.
I mean, that is a terrifying financial spreadsheet for any executive team to look at. When you see a 35% drop in revenue, the immediate corporate reflex is to slash overhead. You have to.
Exactly. And legally speaking, this is the gold standard for what we call a legitimate business reason.
Okay, so define that for us.
Well, employment law generally doesn't care if a company is badly managed or if a layoff is unfair in some, cosmic sense, so long as the termination isn't motivated by illegal discrimination.
Right, right.
So Radial claims that throughout the spring and summer of 2020, their executives were frantically formulating internal cost-cutting plans to just survive the pandemic. They produced internal charts and staffing assessments purporting to show a deliberate plan to eliminate Ramaday's management-level role.
Because they just didn't need him as much.
Exactly. Their argument was simple. They said the new, much smaller Wallingford facility simply didn't require his broad, highly paid skill set anymore. So the corporate narrative is set. They have a shrinking footprint, a global economic crisis, and a mandate to cut costs to survive. It's a very clean, very logical defense on paper.
It really is.
But human biology does not care about a company's negative growth margins or their internal restructuring charts. And that biological reality is what triggers the critical collision course in September 2020.
This is where the timeline becomes, honestly, the most important character in the story.
Walk us through it.
Okay, so it is September 8th, 2020. Ramaday is now 61 years old. He is at work, and he starts feeling terribly ill. And this isn't just a seasonal flu. His symptoms worsen so rapidly that he has to leave work early and is immediately admitted to the hospital.
Oh, my God.
Yeah, he is diagnosed with pulmonary embolisms.
Wait, pulmonary embolisms, that's like blood clots in the lungs, right?
Yes, exactly. This is a severe, life-threatening medical crisis. He is in the hospital for a week, literally fighting for his life.
He survives, thankfully.
Yes, he does.
On September 15th, he is discharged. And the very next day, September 16th, he sends an email to the company. So he emails Lori Musante, the HR director, Richard Broga, his direct supervisor, and Patrice Regaland, the general manager.
Right.
He explicitly tells them he needs time off for the remainder of that week and the following week to recuperate from his health condition, exactly as his doctor ordered. And he tells them he will use his pre-scheduled paid time off, his PTO, to cover the time.
Yep.
He rests, he recovers, and he returns to work, cleared for full duty on September 28th.
And what's fascinating here, and where so many employers get themselves into massive legal trouble, is how the law views that single email from September 16th.
How so?
Well, during the initial phases of this litigation, Radial's defense strategy leaned into a very technical argument. They pointed out that Ramaday never explicitly asked for FMLA leave.
Oh, because he didn't use the acronym.
Right. He didn't use the statutory acronym. He just said he was sick, recovering from a hospital stay, and needed to use his PTO to recuperate. But under the Family and Medical Leave Act, the courts apply a doctrine known as inquiry notice.
Okay, I want to push back on this concept of inquiry notice because this seems like a complete minefield for managers.
It can be.
If I email my boss on a Tuesday saying I'm out for 3 days with a terrible stomach bug and I'm using PTO, is that FMLA? Where is the line for employers between just granting routine sick leave and suddenly triggering strict federal statutory protections? Because it can't be that every single sick day requires a federal compliance review.
It doesn't, and you've hit on the exact friction point that employment lawyers argue about constantly.
Yeah, I imagine.
The line all comes down to the severity of the medical facts the employee provides, and the law places the burden of recognizing that severity squarely on the employer.
Really? Not the employee?
Not the employee. The courts recognize that employees are not employment lawyers. When you were discharged from the hospital after a pulmonary embolism, you weren't thinking about citing Title 29 of the United States Code.
No, you're just trying to breathe.
Exactly. So the rule of inquiry notice dictates that if an employee provides the employer with enough factual information to indicate they might be suffering from a serious health condition.
Wait, how does the law define that?
The FMLA defines it specifically as involving inpatient care or continuing treatment by a healthcare provider. So if the facts point to that, the burden legally shifts to the employer.
So the moment he types the words hospitalized and recuperating per my doctor's orders, the clock starts ticking for HR.
Precisely. The employer is officially on notice. It is HR's legal obligation to read that email and realize, wait, this likely qualifies for federal protection. The employer then has an affirmative duty to inquire further, to ask for medical certification if they need it, and to officially designate the time off as FMLA leave. They cannot just play dumb and say, well, he just asked for PTO, so we didn't think federal law applied.
Which is what Radial tried to do.
Initially, yeah. But to Radial's credit, or detriment, depending on how you look at the litigation, during the depositions for this case, their HR director, Lori Musante, actually admitted that based on the information Ramadie provided in that email, his leave likely qualified for FMLA protection.
Okay, so Ramaday plays by the rules. He communicates his severe illness, he follows his doctor's orders, he utilizes his accrued leave, and he comes back to work on September 28, ready to do his job.
Yep.
You would think the company would just be relieved that their 30-year veteran survived a major health scare.
You really would.
But less than 3 weeks later, they pull him into a room. And what happens next completely shatters this illusion of the loyal corporate family.
On October 16, 2020, his supervisor, Richard Broga, calls him in and informs him that the position of facilities manager is being officially eliminated. He is fired.
But this is where the corporate cost-cutting narrative starts to look incredibly suspicious. Because if a company is truly eliminating a role to save money during a crisis, standard practice is to distribute the essential duties of that role to existing staff and part ways with the employee.
Right.
But Radial didn't just eliminate the function. They had just hired a man named Jason Munson. Munson is in his 30s. They give him the title of maintenance associate, and they pay him roughly half of what Ramaday was making.
Which changes the complexion of the termination entirely. It transitions from a role elimination to just a cheaper, younger replacement.
And then comes the detail that just makes your jaw drop.
Oh, yeah. This is wild.
The sheer audacity of this next move is staggering. Radial hands Ramaday his termination letter, and in that official document, they ask him to stay on for an additional 4 weeks to, quote, transfer his important knowledge, end quote, to his young successor and his supervisor.
It's an incredibly bold request from HR. I mean, wow.
Bold. That is functionally like your spouse asking for a divorce, but asking if you could stick around the house for a month to teach their new younger partner exactly how they like their coffee brewed in the morning.
That is exactly what it's like.
It's wild. The psychological toll of being asked to train the person who is taking your livelihood at half your salary after 30 years of loyalty. I mean, it's unimaginable.
It is.
And Ramaday, incredibly, actually did it. He stayed for the 4 weeks, he trained the new guy, and then he left.
And the post-termination reality confirmed the suspicion. After Ramaday left, the record shows that the vast majority of his old responsibilities didn't vanish. They were simply assumed by this new, younger employee, Munson, and by Ramaday's former supervisor, Broga.
Oh, of course they were.
Right. So the specific title of facilities manager might have been erased from the org chart, but the actual daily labor required to keep the building running was just handed down to a younger, significantly cheaper worker.
Which naturally leads to October 29th, 2021. Ramaday files a federal lawsuit.
Yes, he does.
He brings 5 counts against Radial, and these claims fall into 2 distinct legal buckets. First, age discrimination. He claims this under federal law, the Age Discrimination in Employment Act, or ADA. He also claims age discrimination under state law, the Connecticut Fair Employment Practices Act, the CFEPA.
Right.
The second bucket is FMLA retaliation. He claims he was fired as direct punishment for having the audacity to get sick and take federally protected medical leave.
So now the battle lines are drawn. You have the human drama, the sense of betrayal, the young replacement, and the formal legal charges.
Yep.
But before a case like this ever gets to a jury of everyday citizens, the federal court has to act as a gatekeeper.
Let's talk about that gatekeeping phase.
Yeah.
Because we're talking about the summary judgment phase. How does a federal judge sort through these explosive allegations before a trial even begins? Because it feels like if someone claims discrimination, they should just get to tell their story to a jury.
Right, it feels that way, absolutely. But the federal court system is terrified of being clogged with meritless lawsuits.
Wow.
So when a lawsuit is filed, and after both sides have spent months exchanging documents and taking depositions in a process called discovery, the defendant, so the company, will almost always file a motion for summary judgment.
Which means what exactly?
They are essentially telling the judge, look at all the evidence we've gathered. The plaintiff's case is so weak, or the facts are so overwhelmingly in our favor, that no reasonable jury could possibly side with them. So, judge, dismiss this case right now and save everyone the time and massive expense of a trial.
It's the legal equivalent of a bouncer saying, stop the fight. The other guy doesn't even have his gloves on. Let's just end this.
Exactly. And in employment discrimination cases specifically, judges use a very rigid historical analytical tool to decide if the case survives this motion. It is called the McDonnell-Douglas burden shifting framework.
McDonnell-Douglas.
Okay.
Break that down for us.
It's named after a famous 1973 Supreme Court case. The Supreme Court recognized decades ago that companies rarely leave a smoking gun email saying, let's fire this guy because he's old.
Right. People aren't usually that stupid on paper.
Exactly. Discrimination is usually subtle. So they created this 3-step bands to tease out the truth. Step 1. The plaintiff has to make a prima facie case.
Prima facie.
It just means, at first glance, on the face of it, the circumstances look suspicious enough to suggest discrimination might have happened.
Got it. Okay, so what's step 2?
Step 2. The burden shifts to the employer to provide a legitimate, non-discriminatory reason for the firing, like we talked about earlier with the COVID downsizing.
Right. And then step 3.
Step 3, and this is where most plaintiffs lose, the burden shifts back to the employee to prove that the employer's stated reason is just a pretext.
Pretext, meaning a lie.
Yes, a cover-up designed to hide the real illegal discriminatory motive.
Okay, let's apply that 3-step framework to Ramaday's age discrimination claims. But before we do, we need to address the difference between the federal age claim and the state age claim, because the legal standards are shockingly different.
They are, and this is a crucial legal distinction that trips up a lot of plaintiffs. Under the federal ADEA, the standard is extremely hostile to employees, largely due to a 2009 Supreme Court decision called Gross v. FBL Financial Services.
How hostile are we talking?
Well, the federal standard requires the plaintiff to prove that age was the but-for cause of the firing.
But-for?
Meaning, but for his age, he wouldn't have been fired. Age had to be the definitive deciding factor. The Connecticut state law, the CFEPA, is much friendlier. It only requires proving that age was a motivating factor.
A motivating factor.
Right. It didn't have to be the only reason, just one of the toxic ingredients in the soup that led to the termination.
I have to pause here because that federal but-for standard sounds nearly impossible to prove.
It is incredibly difficult.
Are you telling me, under federal law, if a company fires me 90% because I'm old, but they can prove they fired me 10% because I was late to a meeting once, I lose my federal age discrimination case?
That is exactly what the but-for standard allows. If the employer can prove they would have fired you anyway for that 10% reason, the federal age claim fails.
That's insane.
It is a massive hurdle, which is why plaintiff attorneys rely so heavily on state laws that still use the motivating factor test.
Wow. So how did Judge Janet C. Hall rule on these specific age claims in Ramaday's case? Spoiler alert for the listener. Ramaday lost them. Both the federal and the state age claims were completely thrown out at summary judgments. Let's walk through why, using that 3-step dance. Step 1, the prima facie case. Ramaday actually passed this.
He did.
He was 61, he was highly qualified, he was fired, and his duties were absorbed by a guy in his 30s. The judge said, okay, that looks suspicious enough to clear step 1.
But then we hit step 2.
Right.
The burden shifted to Radial. And Radial came armed with spreadsheets. They showed the judge the severe financial impact of COVID-19, that 34.8% revenue drop.
Which is a huge number.
Right. And they proved they had relocated to a facility less than half the size of the old one. They argued logically that they simply didn't need a high-level $90,000 a year manager to oversee a tiny operation, which is why they brought in a lower-level associate for half the pay.
Okay, so how did the judge react to that?
The judge looked at this evidence and agreed. Corporate restructuring, footprint reduction, and pandemic cost-cutting are textbook legitimate, non-discriminatory business reasons. Radial easily passed step 2.
Which brings the entire age discrimination case down to step 3, pretext. The burden shifts back to Ramaday. He has to prove to the judge that the COVID defense is a total lie, a smokescreen engineered just to get rid of the older worker.
Exactly.
And this is where Ramaday experienced a massive evidentiary failure. He tried to introduce 2 main pieces of evidence to prove a culture of age bias. First, he testified that back in 2015, a former supervisor named William Neal made a derogatory comment about another older employee, allegedly saying that guy was old enough to retire and he should.
Right. But there are strict, unforgiving rules of evidence in federal court. If we look at how courts evaluate evidence, they are constantly filtering for relevance and reliability.
So they didn't buy the 2015 comment?
Not at all. Judge Hall rejected this 2015 comment for 2 fatal reasons. First, it was made 4 or 5 years before Ramaday was fired. In employment law, a comment made half a decade ago is considered a stray remark and too remote in time to prove the company's mindset in 2020.
Okay, what was the second reason?
Second, the manager who allegedly said it, William Neal, didn't even work at the company anymore when Ramaday was fired. He had 0 input on the decision to eliminate Ramaday's role. So the judge concluded that a 5-year-old comment from an ex-manager proves absolutely nothing about why Ramaday was fired today.
Okay, that makes sense. The second piece of evidence Ramaday tried to use was his own testimony that 3 other older coworkers, individuals named Molesky, Petrowski, and Niclario, were all fired shortly after they took medical leave.
Right.
He argued this showed a clear corporate pattern of pushing out older, medically vulnerable workers.
And this is where the rules of evidence can feel incredibly unjust to a layperson. The judge ruled that Ramaday's testimony about his coworkers was inadmissible, hearsay, and pure speculation.
Wait, explain hearsay for us.
Hearsay is when you try to use an out-of-court statement to prove the truth of the matter asserted. Ramaday was essentially saying, Petrowski told me she was fired because of her age. The court's response is, we cannot just take your word for what she said, because you can't cross-examine a rumor, right?
Right.
Furthermore, Ramaday was speculating about the company's internal motives for firing those other people. He didn't have access to their HR files. He didn't have actual proof of why they were let go. He just had his own assumptions and water cooler conversations.
Wait, I really need to unpack the reality of this. If you, as an employee, know something happened to your coworkers, if you see the pattern of older people disappearing with your own eyes, but you can't get those former coworkers to come forward and testify on the record, it just doesn't count in federal court.
That's right.
Does this mean the legal system inherently favors the corporation if employees are too scared or restricted by severance NDAs, or just too exhausted to sign an affidavit and join somebody else's fight?
It is a harsh, brutal reality of civil litigation, but yes, the legal system absolutely requires admissible evidence, and that heavily favors the party with the resources. You cannot defeat a corporate motion for summary judgment with rumors, gossip, or your own personal suspicions about what happened to someone else.
So what do you need?
If you want to use a coworker's firing as evidence, you need affidavits, which are sworn statements under penalty of perjury from those specific coworkers. You need their documents. Because Ramaday didn't have sworn statements from Molesky, Petrowski, or Niclario, the judge was legally required to ignore his stories about them entirely.
Man, that's tough. And without those stories, his pretext argument collapses. He couldn't prove Radial's cost-cutting excuse was a lie meant to cover up age discrimination. So Judge Hall threw out the age claims entirely. They were dead on arrival. Radial seems to be winning a total victory here. Their corporate cost-cutting defense is holding up like an impenetrable shield. But here is the massive pivot in the case.
Oh, this is the best part.
Radial made one fatal error during the discovery process that kept the FMLA retaliation claim alive and sent the company straight into the nightmare of a jury trial.
Let's examine the standard for FMLA retaliation, because it operates slightly differently than age discrimination. To survive summary judgment on this specific claim, Ramaday needed to show 2 things. temporal proximity, meaning the timing of the firing looked highly suspicious, and some additional evidence that the cost-cutting story was actually a pretext to punish him specifically for taking medical leave.
Well, the temporal proximity is glaring. We emphasized a timeline earlier, and it is impossible to ignore. He comes back from medical leave on September 28th. He's fired on October 16th. That is less than 3 weeks.
Right.
That is practically the dictionary definition of suspicious timing.
It is, and the judge readily acknowledged that. In the Second Circuit, which is the federal appeals court that governs Connecticut, a gap of just a few weeks is generally more than enough to raise a judicial eyebrow and establish that first step of an inference of retaliation.
Okay, so he's got the timing.
However, the law is also crystal clear that timing alone is not enough to prove pretext. You cannot just walk into court and say, I got sick, then I got fired, therefore it was illegal retaliation.
Why not?
Well, post hoc ergo propter hoc is a logical fallacy, and courts know it. Just because B follows A doesn't mean A caused B. You need something more, some concrete evidence to show the employer's stated timeline is a lie.
And this is exactly where Radial's defense implodes. It all comes down to the depositions.
Yeah.
Now, a deposition is when the lawyers get to interrogate the opposing side's witnesses under oath, with a court reporter typing down every single syllable months before the trial. It is an incredibly high-pressure environment. Plaintiff lawyers will spend hours meticulously boxing a witness into a corner. Ramaday's lawyers deposed the executives at Radial. And incredibly, despite all their preparation, the executives couldn't get their story straight on the most critical, foundational question of the entire case.
Which was, when exactly did they decide to fire Gary Ramaday?
Right.
This is the smoking gun, and it highlights the psychological difficulty of defending a corporate action when multiple decision makers are involved. Let's look at the general manager, Patrice Rigoland. Under oath, he swore that the decision to eliminate Ramaday's position was made, quote, right after the COVID crisis, end quote, or when they moved to the new Wallingford facility.
So, spring of 2020.
Right. He is claiming, on the record, that this decision was locked in way back in the spring or early summer of 2020, long before Ramaday ever got sick in September.
And if that's true?
If the judge believes that is true, Radial wins the case instantly. You simply cannot retaliate against someone for taking medical leave if you had already finalized the decision to fire them months earlier. The timeline protects the company.
But then, Ramaday's lawyers sit down in a different room on a different day with Lori Musante, the HR director.
Oh, boy.
Under oath, she completely contradicts her own general manager. She testifies that the decision-making process regarding Ramaday's employment was iterative and fluid. She explicitly states on the record that right up until October 2020, which is after his medical leave, she was still actively hoping that, quote, things would change and they wouldn't have to eliminate his role at all.
This raises a massive, insurmountable problem for the defense, and it is the exact question Judge Hall asked in her ruling. How can a corporate decision be completely set in stone in the spring, but also be iterative, fluid, and undecided until October?
Right.
The logical answer is it can't be both.
So why is this specific contradiction so fatal at the summary judgment phase? Why couldn't the judge just look at the emails, look at the 25% revenue drop, and say, look, I believe the general manager misspoke. The company clearly needed to cut costs. Case dismissed.
Because judges at the summary judgment phase are strictly forbidden from weighing credibility or deciding who is telling the truth.
They're not allowed to.
No, they cannot look at two conflicting transcripts from company executives and say, I believe the general manager's memory is better than the HR director's. If there is a genuine dispute of material fact and the exact timeline of when a man was chosen for termination is the most material fact in a retaliation case, the judge must step back.
So their hands are tied.
Exactly. The judge has to say, I cannot resolve this conflict on paper. Only a jury can decide which executive is lying or misremembering. Because of that single inconsistency, because HR admitted the decision wasn't final until after Ramaday took his FMLA leave, the judge ruled that a jury had to hear this case.
Wow.
They had to decide if the sudden severe medical leave was the actual trigger that finalized the supposedly fluid decision.
It is a stunning unforced error. Because the executives didn't get their timeline perfectly aligned, because they gave contradictory testimony under oath, Radial lost their golden opportunity to have the whole case quietly dismissed by a judge.
Yeah, they blew it.
They were dragged out of the safety of the judge's chambers, forced to spend hundreds of thousands of dollars on trial prep, and thrown into a courtroom to face a jury of everyday citizens. Which brings us to the climax of the story: the trial, the holding, and the payout.
The trial takes place in late 2023. Imagine the dynamic in that courtroom. You have a jury of regular people, many of whom have likely dealt with corporate layoffs or medical emergencies themselves, listening to this whole narrative unfold.
Oh, they must have been eating it up.
They hear about the 30 years of loyal service. They hear about the terrifying medical crisis. They hear about the 20-something replacement hired at half the cost. They hear the incredibly tone-deaf demand that Ramaday stay for 4 weeks to train his replacement.
Which is just the worst look.
It's terrible. And then the plaintiff's attorney puts those conflicting deposition transcripts up on a screen, showing the executives contradicting each other about when they actually decided to do it. Juries historically despise when corporate witnesses cannot get their story straight. It reeks of a cover-up.
And on December 8th, 2023, the jury deliberates and returns their verdict. They find in favor of Gary Ramaday on the FMLA retaliation claim. They award him $187,714 in back pay.
Yep.
That is the jury emphatically stating, "We do not believe your cost-cutting timeline. We believe you punished this man for getting sick."
Now, before we get to the final financial fallout, there is a highly technical but absolutely vital procedural detail from the source material regarding the immediate aftermath of this verdict.
Oh, right, the appeal attempt.
Yeah. Radial's defense lawyers, desperate to save the case, tried to fight back after the trial concluded. They filed a motion arguing that the jury's verdict sheet was internally inconsistent.
Inconsistent.
They claim the jury's specific findings regarding retaliation fundamentally contradicted their findings regarding whether the company acted in good faith.
Wait, if the jury fills out a verdict sheet and the answers literally contradict each other on their face, wouldn't that be a slam-dunk procedural error? Shouldn't Radial be able to just immediately appeal that and get the whole $187,000 verdict thrown out?
It might have been a brilliant argument, except the appeals court shut it down instantly. They noted that Radial waived this argument.
Waived it? How do you waive an objection to a broken verdict sheet?
By failing to speak up at the exact right millisecond.
You're kidding.
No, I'm serious. The appeals court ruled that Radial's lawyers didn't raise the objection to the verdict sheet before the jury retired to deliberate.
Hello.
The logic of trial procedure is brutal but necessary. You have to give the trial judge a chance to fix any confusing instructions or contradictory forms before the jury makes a decision.
So you can't just let it play out.
Exactly. You cannot just sit on your hands, wait to see if the jury rules against you, and then complain that the form they used was confusing. It is an incredibly harsh lesson in the strictness of trial procedure.
That is brutal.
The appellate courts are incredibly unforgiving of lawyers who miss their window to object. Because they waived it, the jury's verdict stood.
And that procedural failure opened the floodgates. Because that $187,000 jury verdict, that was just the appetizer. Fast forward to September 16th, 2024. Judge Hall issues the final holding on all the post-trial motions. This is where the math gets absolutely brutal for the employer.
It really does.
Let's break down these categories of damages because they skyrocket. First, the judge awards liquidated damages in the amount of $206,041.71. What exactly are liquidated damages in this context?
Liquidated damages in FMLA cases act essentially as a severe penalty. The statute explicitly allows the court to effectively double the plaintiff's economic damages if the employer cannot prove they acted in good faith with reasonable grounds for believing they weren't violating the law.
So it's basically a punishment multiplier.
Exactly. Given the jury's findings that this was intentional retaliation, the judge slammed Radial with this maximum penalty, doubling their financial pain. It's the court's way of saying you didn't just make an administrative error, you acted recklessly and maliciously.
Next, the judge awards front pay in the amount of $186,859.34.
Front pay is a fascinating legal remedy. Under most employment statutes, the preferred default remedy for a wrongful termination is actually a reinstatement.
Like they have to hire him back.
Right. The court orders the company to give the person their job back. But courts live in reality. In a case like this, years have passed. The litigation has been bitter, accusatory, and exhausting.
Yeah, I wouldn't want to go back there.
Exactly. The plaintiff's specific position was supposedly eliminated and absorbed by others anyway. The trust is completely destroyed. Reinstatement just isn't feasible. It would be a toxic environment from day one.
So they're just paying for the future instead.
Yes. The court calculates what Ramaday would have reasonably earned in the future at Radial if he hadn't been wrongfully terminated. Factors in his duty to try and find other work, discounts it to present value, and forces the company to pay it out to him as a lump sum now. That calculation resulted in another almost $187,000.
Then we have prejudgment interest of $18,327.72. which is essentially just compensating him for the time the company illegally held onto his money while the lawsuit dragged on.
Yep.
And finally, the category that terrifies corporate accounting departments the most, the legal bills, attorney's fees and costs. The judge ordered Radial to pay $163,229.50 in legal fees directly to Ramaday's lawyers, plus another $7,833.79 in specific court costs.
This is due to what are called fee-shifting statutes. Normally in the United States, we follow the American rule where everyone pays for their own lawyer, win or lose.
Right.
But in civil rights and employment laws, including the FMLA, Congress specifically wrote in fee-shifting provisions. If the employee wins even $1, the employer has to pay the employee's legal bills.
Wow, even $1.
Yes. The rationale is to encourage private attorneys general, to ensure that regular working-class people can afford to hire highly skilled attorneys to fight giant, well-funded corporations.
That makes total sense.
But for the company defending the suit, it changes the entire calculus of going to trial. It means you aren't just paying your own expensive defense lawyers. When you lose, you are suddenly writing a massive check to the plaintiff's lawyers, too.
So we add all of this up. The jury verdict for back pay, the punishing liquidated damages, the future front pay, the interest, and the plaintiff's legal fees.
Yeah.
The final grand total entered by the court against Radial, $770,006.06.
It is the ultimate cautionary tale for corporate management. Think about the pure economics of what Radial tried to do here. They looked at a spreadsheet and tried to save money by cutting a 61-year-old manager's salary. They brought in a 30-something associate for half the price to do the same work.
Right.
But because they executed this supposedly cost-saving measure with horrible, indefensible timing, right after a federally protected medical leave, and because their executives couldn't keep their timelines straight under the pressure of a deposition, this one cost-saving move ended up costing the company $750,000.
It's incredible.
It wiped out whatever marginal payroll savings they hoped to achieve and likely cost them hundreds of thousands more in their own defense fees.
It is a staggering, self-inflicted backfire. Which brings us to the end of our discussion today. If you are an employee listening to this, the takeaway is absolute. Document everything. Know that the exact timing of your medical leave is fiercely protected by federal law.
Absolutely.
Do not be afraid to clearly and explicitly state your medical needs in writing to HR, because that paper trail is your shield. And if you are an employer, an HR professional, or a manager, let this case keep you awake at night. You must ensure your corporate decision-making timelines are meticulously documented.
They have to be.
They must be consistent across every level of management, and they must be absolutely airtight before you execute a termination, especially if that termination happens anywhere near an employee's medical leave. You simply cannot have your general manager and your HR director telling two different stories under oath about when a decision was made.
As we've seen, it is quite literally the difference between executing a clean, defensible corporate restructuring and getting hit with a $770,000 federal jury verdict.
It certainly is. And as we wrap up, I want to leave you with a broader, somewhat darker societal question to ponder on your own. We saw in this case how Radial used a very real shift from mechanical to digital production to justify shrinking their physical footprint, which in turn became their primary defense for eliminating an older worker's role.
Right.
As automation, artificial intelligence, and remote work continue to radically and rapidly shrink the physical footprints of companies everywhere, how many future role eliminations are actually just going to be incredibly convenient legal cover stories?
That's a great question.
How many of these technological shifts will be quietly weaponized to push out aging, highly paid, or medically vulnerable employees who simply cost too much on the balance sheet? And, perhaps most concerning of all, how many companies will actually get away with it simply because their HR departments practice their deposition testimony a little bit better than Radial did? Thank you to our expert for being here today, and thank you for joining us for this Employee Survival Guide. Stay safe out there in the workplace.
If you like the Employee Survival Guide, I'd really encourage you to leave a review. We try really hard to produce information to you that's informative, that's timely, that you can actually use and solve problems on your own and at your employment. So if you like to leave a review anywhere you listen to our podcast, please do so. And leave 5 stars, because anything less than 5 is really not as good, right? I'll keep it up. I'll keep the standards up. I'll keep the information flowing at you. If you'd like to send me an email and ask me a question, I'll actually review it and post it on there. You can send it to Carey at capclaw.com. That's capclaw.com.